If you're planning to apply for a green card while living in the U.S., a major immigration policy update could completely change your path. USCIS has announced a new approach to adjustment of status processing, and it's already creating concern among immigrants, students, workers, and families across the country. For years, many applicants were able to stay inside the U.S. while applying for permanent residency. But now, USCIS says that process may only be available in rare and exceptional situations. Here are the 5 biggest things everyone should understand about this new policy change. Hello, everyone. Welcome back to our channel, U.S. Immigration News. 5 major changes in USCIS green card processing you need to know. Now, first of all, we talk about 1. Adjustment of status could become extremely limited. The biggest headline is this. USCIS now says adjustment of status inside the U.S. should only be approved in extraordinary circumstances. That means most immigrants seeking permanent residency may no longer be able to simply file for a green card while remaining in the country. Instead, the government wants applicants to complete immigrant visa processing abroad through a U.S. consulate. This marks a dramatic shift from the system many applicants have relied on for decades. USCIS describes adjustment of status as a special discretionary benefit rather than a standard option available to most people. However, there may be an important exception for certain work visa holders. The policy memo suggests H-1B and L-1 workers, along with their H-4 and L-2 dependents, could face less impact because these visas allow dual intent. Dual intent means a person can legally hold a temporary work visa while also planning to become a permanent resident in the future. Still, USCIS warns that simply having H-1B or L-1 status does not guarantee approval. Officers will still decide each case individually. Now, we talk about the second point. Many applicants may need to leave the U.S. Another major change is that temporary visa holders could now be expected to leave America and apply for immigrant visas from their home countries. This could affect international students, tourists, temporary workers, and other non-immigrants hoping to transition into permanent residency while already living in the U.S. Under the new approach, USCIS appears to be discouraging people from using temporary visas as a pathway to remain permanently in the country. Instead, applicants may need to return overseas and complete the process through the Department of State. For many families, this raises concerns about travel costs, long visa wait times, job interruptions, and uncertainty during consular processing. Let's talk about the third point. Every case will still be reviewed individually, even with the stricter policy. USCIS says officers must continue making decisions on a case-by-case basis. The memo instructs officers to review the totality of circumstances before deciding whether someone deserves in-country adjustment of status approval. Several factors may now carry significant weight, including immigration violations, fraud or misrepresentation, unlawful conduct after entering the U.S., and failure to follow visa conditions or depart on time. USCIS also says officers may consider family ties, immigration history, current legal status, and overall moral character when reviewing an application. Importantly, the memo highlights overstaying a visa or violating admission rules as highly negative factors that could strongly hurt an applicant's case. For USCIS never clearly defines extraordinary circumstances. One of the most confusing parts of this policy is that USCIS never actually explains what qualifies as extraordinary circumstances. There's no checklist, no official examples, and no clear definition in the memo. Instead, officers are told to use broad discretion while reviewing applications individually. That uncertainty is creating major concern because applicants may struggle to understand whether they even qualify before applying. Immigration attorneys are already warning that this lack of clarity could lead to inconsistent decisions depending on the officer reviewing the case. Finally, we talk about the fifth point. USCIS says the goal is enforcement and efficiency. According to USCIS, the purpose of this policy is to reduce illegal overstays and better manage agency resources. The government argues that requiring more applicants to process from abroad lowers the risk of denied applicants remaining in the U.S. unlawfully. USCIS also says the shift will help free up resources for other immigration priorities, including naturalization cases, humanitarian programs, and visas for crime and trafficking victims. The agency insists this is not a brand new law, but rather a stricter enforcement of existing immigration policies and past court decisions. For immigrants already planning their green card journey, this announcement could have serious long-term consequences. And with so many unanswered questions still surrounding the policy, immigration experts expect intense legal and political debate in the months ahead. And that's the latest update on the new USCIS adjustment of status policy. These changes could impact thousands of immigrants planning their green card journey, so staying informed is more important than ever. If you found this video helpful, make sure to like, subscribe, and turn on notifications. Thank you,